Okay, in this chapter, we're going to talk about racial discrimination and the effects of that in the criminal justice system. So let's start with some historical background. Generally, I think we can all agree that discrimination based on race and ethnicity is wrong, and it violates that earlier principle we talked about, that principle of equality, right? And that requires us to treat people who are equal, people who are similar, to treat them equally, and that race is not a relevant consideration in that assessment. The only time we could justify treating people differently is if there is some factual difference that justifies different treatment. So let's start with clarifying something here. The difference between race and ethnicity. So ethnicity refers to a cultural phenomenon, your identification with a cultural group, your ancestors. And race is race is a sociological concept where sociologists divided the world into three races. It's a social construct that has no biological meaning, and it really gradually takes hold during slavery. So when we talk about racism, we're talking about practices that attribute merits or allocate values to members based solely on their race. Okay? Now, this can happen on a personal level, can happen ideologically, and at the institutional level. So when we talk about it ideologically, we're talking about how culture and biology are used to rationalize and justify the superior position of a dominant culture. And institutionally, we're talking about policies and practices that produce systemic and continuing differences based on race. So institutional racism, one thing we want to talk about is grand apartheid and petite apartheid. You're really familiar with grand apartheid. That is the system that really existed in South Africa. That's overt racism. But petite apartheid refers to daily informal or hidden interactions. And here we're talking about between the police and minorities. So things like stop and queue and stop and search law enforcement practices. And the focus tends to be on the attitude that influences policing and other decisions. So thinking about this historically, we know that Blacks have suffered racial discrimination. We know that we've got the issues of slavery, then we've got segregation, we've got Jim Crow laws. And from the inception of slavery until about 1865, slaves were property. And this was based on the idea that they were somehow naturally unequal and inferior. And therefore, they were subject to regulations as any other property would be. And so it was fair for you to treat them brutally or inhumanely. Post-Civil War, there's a series of amendments that prohibit slavery and give all people, regardless of race, a right to equal protection. But then states start passing Jim Crow laws. And these basically have the same impact in terms of access to legal rights. So African Americans were denied the right to vote, to enter into contracts, and we also have the doctrine of separate but equal. And the courts continue to enforce this until the mid-1900s. We also see a lot of extra legal treatment in terms of physical assault and lynching, and police were often present during lynching. From the mid-1800s to the early 1900s, about 3,000 African Americans were lynched. And the people performing the lynchings were seldom prosecuted for that. In 1954, we get a landmark case, Brown versus the Board of Education. And this strikes down this idea of separate but equal. And it's dealing specifically with schools, but it's also talking about separate but equal as a whole. We also want to remember that when we talk about the Black community, we're talking about a wide and diverse culture, wide and diverse community. Jamaicans, Nigerians, Ethiopians. And despite the fact that they're very different, they're treated similarly based on skin color alone. Native Americans and Alaska Natives are our only indigenous people, and there's a long history of violence towards them as well. So in Alaska, there's a lot of trauma generated by social change, and that's resulted in high rates of suicide, alcohol abuse, and disproportionate representation in the criminal justice system. And we see a very similar thing with Native Americans as well. We also want to remember that today, a lot of the land that we think of, well, that is part of the United States, once belonged to Mexico. So Mexico had lost half its territory to the U.S. in 1847. And so Mexicans tend to be really painted as our illegal immigrant group here. And we depict them often as racy, sneaky. But we also want to remember that Latinos are also a diverse group. So Cubans that immigrated here were often middle class, well educated, and had a lot of economic resources. So we just want to remember that when we group people together based on skin color, we're really taking very different populations and lumping them all together. So is there discrimination in the criminal justice system? Well, it depends on exactly what's being studied. So there's a commission on the LAPD in 1991 that's called the Christopher Commission, and they found that excessive use of force by LAPD officers was compounded by racism. A quarter of the officers held a racial bias towards minorities. And they reviewed radio transmissions, and they revealed a lot of recurrent racial remarks being made while discussing vehicle pursuits or beating suspects. Witnesses also reported verbal harassment, detaining blacks and Latinos who fit general descriptions, invasive, humiliating tactics in minority neighborhoods. And this was also reflected in their conduct towards their fellow officers who were also from minority groups. In 1991, New York State had a commission that looked at this as well, and they found that there were two systems of justice in New York, one for whites and a very different one for minorities and the poor. And they often received what was called basement justice, in court facilities infested with rats and roaches. Their family members were treated disrespectfully. There was a lot of racist graffiti on the walls, and they often only got 4 or 5 minutes in court. So going through the court process was treated like an assembly line. You know, go to the next stop, get whatever happens there, and move along. So how do we determine if racism exists? Well, one thing we want to think about is overt racism versus covert racism. So a lot of research looks at specific decision points. And so there is a racial discrimination in the system, but it's not as overt as one might think it is. It's not as systemic. What happens is you've got various decision points, and the further one gets through the pipeline of the criminal justice system, with each of those points having some discrimination, the more discrimination one's experiencing. So a lot of disparities have come about because of procedures that were adopted without really thinking about how they might impact different groups. So one thing that might happen is different groups of people might receive longer sentences, and that could be due to differences in plea bargaining and jury trials. But what studies tend to look at then is easily identifiable formal decision-making points, but that, of course, doesn't take into account any informal discretion, who's arrested and who enters the system to begin with. So since those are, and the reason people don't look at those is they're harder to study, and there's a lot of discretion there. So we have when we look at primary classification schemes, we have 4 races that are often tracked by the government: white, black, American Indian, Alaskan Native, and Asian Island Pacifica. And then as far as ethnic groups, we look at Hispanic, not Hispanic. But races in America are not monolithic. So black includes people from the Caribbean, Africa, Central and South America. And so these are really political definitions. So in the juvenile justice system, any discrimination here should be considered separate from the adult system. There's a lot of discretion, but most adult offenders begin their contact in the adult system through the juvenile justice system. So how they're treated there may influence what happens to them in the adult system. So about 2/3 of studies show that there is evidence of direct and indirect discrimination, especially in terms of how people are processed. And as I mentioned before, while it may be minor at any given point, there is a cumulative effect there. So let's start with police encounters. So we know that one thing that's really important in interactions with the police is your demeanor, right? So if you're perceived as being disrespectful, that increases the likelihood of an arrest. The context of the neighborhood you're in also influences that discretion. Police are more likely to threaten arrests or use force in racially mixed or minority neighborhoods. And so what about bail? There's wide discretion for bail in most cases. Generally, we're looking at possibility of flight and dangerousness to the community. So the court is going to look at your ties to the community. And if you are employed, you're married, you've lived in a particular place for a long time, the court may conclude you have strong ties to the community and therefore are unlikely to flee. And race should not be a factor here, but it does relate to decisions of bail. So the lower the level of education or income, the less likely someone is to get bail. White defendants with the same education, background, and income as black defendants were more likely to be granted bail. Prior criminal record seems to count against blacks more than whites. And dangerousness and seriousness of crime were given greater weight to whites. So it's possible that the way minorities are stereotyped as being less reliable and more prone to violence will result in a greater chance of them being denied bail. In terms of jury selection, in Strouder v. West Virginia in 1880, the court struck down a statute that limited jury selection to white men. They said that this violated the 14th Amendment. But the state then tries to preserve an all-white jury through other means. So in Delaware, names were drawn from lists of taxpayers, and they were required to be sober and judicious. State authorities explained that few African Americans were intelligent or experienced or moral enough to serve. In other places, people put like the names of white jurors on white cards and black jurors on yellow cards and then randomly drew jurors, and the Supreme Court ruled that unconstitutional. But there are still practices, while they are not overtly discriminatory, are discriminatory. If we're pulling lists from property taxes or registered voters or lists from the who has a registered car, you may be skewing towards certain groups, and it tends to stack the jury pool with white middle class. We also know that when selecting a jury, you have challenges for cause and peremptory challenges. Peremptory challenges you can use for any reason, and they can also be used, they're often used to excuse potential jurors. Initially, the Supreme Court didn't want to put any restrictions on this, but they did say that if a defendant could establish a case of deliberate discrimination by showing that eliminating African Americans was a pattern in a jurisdiction. But this is a really tough test to prove. And in 1986, the Supreme Court rejected it. It said you need to bring evidence showing the prosecutor has exercised the peremptory challenges on racial grounds. Once you can show that prima facie case, then the burden shifts to the state to show why a black juror was excluded. But the benefit of the doubt is often given to prosecutors, and they can often come up with another reason as to why they excluded a potential juror. In terms of conviction and sentencing, in the aggregate, just raw numbers, there are fewer black convicts than whites, okay? But there are fewer black people in the United States than white people. There's no consistent evidence of racial discrimination at the point of conviction, but prior criminal record does affect you. Once that's controlled for, the direct effect of race is eliminated. But racial disparities in sentencing arise from disproportionate representation in the processing of criminal conduct. We often see this in terms of longer or more serious criminal records. And so, as I mentioned before, race has a cumulative effect. It's interacting with other factors. So let's start by investigating the victim's status. Or they often start by investigating the victim's status. It also includes crimes like drug processing. So in New York, low-level black dealers in New York were treated more leniently than white, but major black dealers were treated more harshly than their white counterparts. They were perceived as inflicting still more harm on an already victimized non-white population. Current research looks at things like 3 strikes. Once controlling for prior record and other variables, racial disparity is not a result of discrimination. But again, we want to remember what's happening in those prior points. We can also think about the role of the prosecutor, where sentences are fixed and plea and charge bargaining become crucial. In LA County, cases against Hispanics and blacks were significantly more likely to be prosecuted than those against whites, and white defendants were offered more pleas and better deals. We also want to think about macro level factors. How does poverty, urbanization, and other similar factors play a role in sentencing? There's a considerable growth in the number of the very poor, and there's a lot of economic gaps here. The black middle class has grown significantly, but the percentage of African Americans among the very poor has also increased. And if we just look here, these are numbers from 1991, but look at the major difference between median wealth. Let's look at some imprisonment disparities. Black inmates are about 46% of all inmates with a sentence of more than a year, and white and Hispanics account for 36 and 16% respectively. Nearly 10% of all black males between 25 and 29 were in prison, compared to 2.9% of Hispanics and 1.1% of white males. So what can account for this? Well, we have about a 10-15-year period there where we have an enormous growth in the rate of imprisonment. And the number of drug offenders increased nearly 10 times. So that did little to change the level of racial disproportionality. So the war on drugs becomes a major factor here. Black inmates are over half of all offenders convicted of drug offenses, serving time in state prisons. In terms of the death penalty, once we control for the type of homicide, race is a factor in the prosecutor's decision to seek the death penalty and in its imposition. But what's really important here is the race of the victim, together with the race of the offender. So black offenders who murder white victims are most likely to get the death penalty. Offenders convicted of murdering black victims are least likely to get the death penalty. In terms of hate crimes, acts of racial discrimination could rise to the level of a hate crime, and there's two different ways this is addressed. In some states, it's treated as a separate, independent offense, and in other states, if you could prove hate as the motivation for the crime, a sentencing enhancement, so additional time is added to the sentence. But in order to do this, we have to establish the motive of the accused, which can be very difficult. It can be established by language used by the offender. We can also look at the severity of the attack, provocation by the victim, prior history of conduct, and similar incidents in the same area. Over half of all hate crimes are motivated by race, and the majority involve in violent offense. So, how do we explain this? You can think about consensus theory and conflict theory. Remember, consensus theory says that community has a general consensus of what they think is right and wrong, and the law reflects that. Conflict theory says there's a lot of groups with conflicting values in society, and the state basically represents the interests of the powerful ruling class. So any groups that threaten that power could be subject to more control. And that can include minorities, the unemployed, and the poor. So what are some examples of this? Well, vagrancy laws. Being a vagrant is when you occupy public space without resources and no clear purpose for being there. So only the poor engage in vagrancy. So when it's a crime, it's an attempt to control the poor. Street crime today is a primary target of law enforcement, and that's committed disproportionately by poor and ethnic and racial minorities. But we don't see a lot of enforcement of white-collar crime, which is committed by middle and upper-class whites. There's also a symbolic aspect here. Perceptions of threats are often reflected in crime control policies. In Washington state, non-whites sentenced to prison at higher rates in counties with large minority populations. When they interview leaders in that community, criminal justice leaders, they often talk about the public concern with dangerousness and the threat from minorities. So crime was really perceived as a minority problem here. After reviewing most of the research, Thompson and Lauritsen said discrimination appears on occasion at some stages in some locations. There isn't a lot of evidence of overt or systemic bias, but perceptions of racial discrimination is fueled by moral panics and our responses to the war on crime, war on drugs. Maurer did some research looking to account for the striking increase in the proportion of African Americans incarcerated in the U.S. In 1926, they were only 21% of those in prison, and today they're half of all prison admissions. So perhaps the explanation is rooted in society's response to crime, noting that most crime is intraracial. And so basically, he's arguing that society wasn't as concerned about it when black crime was located in black communities against black people. Once it was perceived to spill over into white communities, we started to get a little more proactive about this. And he argues that the death penalty provides some evidence for this. So race plays a very subtle role. White offenders may benefit from greater resources. They can afford costs of substance abuse treatment and might be able to arouse less unease in decision makers. And so although everyone is entitled to legal representation, the quality of that representation varies. So public defenders are underpaid, poorly trained, and lack resources. So let's take the example of marijuana. In the 1900s, it's perceived to be a drug used only by blacks and Mexicans. In the 1950s, it's penalized with a sentence of 2 to 5 years for first-time possession. In the 60s, it's widely used by whites, and it starts to be perceived as relatively harmless. And then in the 70s, it gets separated from other narcotics and given lower penalties. But in practice, law enforcement activity varies regarding marijuana. In the city of Milwaukee, possession is a misdemeanor. In the suburbs, it's a mere ordinance violation. So Tonry argues that those who launched the war on drugs knew the enemy would be mostly young minority males. We also know that drug arrests in inner city neighborhoods are easier because they're dealing in an open air market. And the war on drugs also increased targeting of black working and middle class areas for drug enforcement. This has disproportionately also affected women of color. They generally are unable to negotiate any beneficial pleas because they often don't have information to exchange. In 1999, the Sentencing Project revealed that the number of women incarcerated for drug offenses rose 888% in a 10-year period. So there's also a disparity in terms of powder and crack cocaine sentencing. So the sale of 500 grams of powder is in 5 years, and the sale of 28 grams of crack is also 5 years. There's very little chemical difference between crack and cocaine. And powder is used mostly by middle and upper class, whereas crack is used mostly in urban areas. And that wraps up this chapter on racial discrimination.